Good afternoon. Our next case is Schroeder versus the Oak Grove Farm Homeowners Association. We will hear from the appellant.
May it please the court. My name is Jeffrey Kuykendall, and I, along with my partner Colin Scott, represent the Oak Grove Homeowners Association, what I refer to as the HOA. I'd like to reserve 7 minutes for rebuttal. The primary issue in this appeal is the Court of Appeals' decision to reverse the decision of the jury that plaintiffs Craig and Mary Schroeder violated the HOA's restrictive covenants. There are also some ancillary issues raised by the plaintiff concerning the conduct at trial. Very briefly as to the facts, plaintiffs own property in the HOA. The declarations or restrictive covenants of the HOA provided under Section 13, the livestock provision, that a maximum of 3 horses may be kept and stabled on any lot or combination of adjoining lots under common ownership. No other animals, livestock, or poultry of any kind shall be raised, bred, or kept on any lot except that dogs, cats, or other household pets may be kept, provided that they, including horses, are not kept, bred, or maintained for any commercial purpose. Plaintiffs who had dozens of chickens on their property were warned that they were violating the declarations. A hearing was held and they were fined. Plaintiffs sued, claiming they were not in violation of the declarations because the chickens were their household pets. Trial was held, evidence was convened, credibility was determined, and the jury determined that the chickens were not household pets, and therefore there was a violation of the declarations. I believe both parties agree that there are, in essence, 2 Court of Appeals decisions that are directly on point in this case, and that's the Steiner versus Windrow Estate Homeowners Association case and Bryan versus Kittinger. In Steiner, just briefly, a 2011 case, there were 2 Nigerian dwarf goats who were unable to breed, unable to produce milk, and they were determined to be household pets. Both sides, the Homeowners Association and the plaintiffs, filed summary judgment. Both indicated that the facts were not in dispute. And the court found that as a matter of law, the goats were household pets. There was no utility demonstrated. There was no evidence that they were treated as anything other than pets. And there were 2 of them. In Bryan versus Kittinger, which is a 2022 case and is, I believe, more informative, there were 4 chickens or hens kept in the backyard of the homeowner. The HOA filed a motion for summary judgment, which was granted. However, the Court of Appeals reversed, noting that no one was entitled to summary judgment, and the summary judgment was granted on the basis that they were poultry and the other pets was not addressed. The Court of Appeals pointed this out and said, importantly, relying on this court's decision in Kidd versus Early, 1976 decision, that it is true that defendants put on evidence tending to show that they consider their hens as household pets, and they do not sell eggs laid by the hens. But our Supreme Court has instructed that a summary judgment motion should ordinarily be denied, even though the opposing party makes no response or the witness is inherently suspect because he is interested in the outcome of the case and the facts are peculiarly within his knowledge. Here, though, defendants state that they consider their hens as pets, the fact finder could disbelieve them.
So I have a question for you.
Of course.
What was the fact dispute, in your view, that was being resolved by the jury in this case?
In this case, whether they were household pets, which involved a number of factors, including on their side and what they point to, how they treated the animals, whether they named them, things of that nature. On our side, how many there were, did they know their names, did they use them for utility or simply for enjoyment, things of that nature.
I didn't see the trial court instructing the jury, this is what a household pet is. Now you go resolve these fact disputes so you can, whether or not they ever sold the eggs, how many chickens there are, all these things, so that you can then apply that to my legal definition of what a household pet is.
I don't think the trial judge needed to define what a household pet was, because I believe that the jury could determine based on their ordinary knowledge and living in the community what it means to be a household pet.
Well, and that's what I wanted to get to, because this is the problem I have with this case. I'm not sure that there's any one answer to that question. And what seems to me something that I didn't see the Court of Appeals ever grapple with in these earlier cases, and I know it wasn't something that was a lot of focus in the briefing in this case, but we have this doctrine that restrictive covenants, like the type that homeowners associations apply to all the members of the association, are disfavored because they put this burden on land that makes it hard to sell. And so we, the court system, say, if we're ever called upon to interpret the meaning of one of those restrictive covenants, if there's an ambiguity, we must construe that in favor of the free use of the land. And we've had a series of cases involving zoning where we've tried to sort of reinvigorate this doctrine because it had kind of fallen away. And I'm wondering if this is an opportunity for us to do the same thing here and say, well, whatever household pet means, we have to construe it in favor of the homeowners here, whatever their view of what a household pet would be. And then my question is, if we think the law requires us to do that, didn't that mean that the judge had to instruct the jury, this is what a household pet is, the favorable understanding of it, and then let them see if there were any fact questions that would be relevant to that definition?
Well, I think there's multiple parts in that question, Your Honor. I don't disagree with the existence of the law, that free use of the land, that there is that priority. I think here that is the essence of what a jury is here for, is to make these determinations when there is an ambiguity. This isn't the procedural posture of this case does not come to you where the HOA has won on summary judgment or directed verdict or any other similar procedural posture. It comes to you after a jury trial in which the jury has been asked, based on all the circumstances, on all the evidence, all the documents, all the testimony, do you believe these are household pets? And these aren't terms that are foreign to a jury.
But here's the problem with that. Like, even take the Steiner definition. So the Court of Appeals said this is what it means. And they said it's domesticated animals, that, and so on and so forth. But in my view, if I went to someone's home and I went in and they had some children and they were like, look at our pet hermit crabs. And they showed them to me in a little terrarium. And I would look at those. I would say, well, those crustaceans are not domesticated, but I would certainly consider them household pets. And so it seems to me that part of the problem is this is an incredibly ambiguous term that's very subjective. Whether something is a household pet to you may be different than someone else who would say that animal could never be a household pet. And that what we have to do in an individual case is understand what was the meaning to the landowner and have the judge say this is the legal definition by operation of law in this case, and now figure out if there's any fact questions that need to go to the jury. And I don't see that happening here.
Your Honor, I guess I would quibble with the way you approach it. I would approach it in the sense of, here's your hermit crab, have the testimony, have the child, the family that owned the hermit crab testify, what's the name of the hermit crab, how do they use it, how do they interact with it, have the homeowners association put on whatever evidence they have that it is not a pet, and then we have a jury system for that very purpose to resolve those ambiguities, questions of fact. And that's what was overturned in this case. And I think that was the problem in this case, is that we are not here before you because we won, because a judge told us we won. We are here before you because the jury said, it means the Justice Potter Stewart quote, I know it when I see it. Little different context, but I know what a pet is when I see it. And they could have evaluated your hermit crab and said yes, no, or either way, and that's how these cases should be addressed.
But I guess that is exactly what I'm struggling with. Exactly what you just said, which is, what if some members of that jury said, well, I don't think chickens can ever be household pets. You don't let them inside your house to go around like a dog or a cat. And they're applying their understanding of the ordinary usage of that term. And don't we have to give the jury the legal definition, because there must be one? This is a term in a recorded instrument, so the meaning of the term is a question of law.
I don't think the meaning of the term household pets is a question of law. I think the meaning of the term, it can be defined by a dictionary definition, like they did in Steiner. It can be just your ordinary experience.
But as I just pointed out, the dictionary definition in Steiner doesn't even work. I mean, if you apply that, a hermit crab can't be a household pet, and that seems to me that can't be right.
And so I analogize it to the situation where when you need an expert involved in a case, you do need an expert when you're talking about something complicated that is outside the ordinary understanding of the jury, whereas you don't need one when you're talking about something that is within the ordinary understanding of a jury. And I think that's what we have here, and that's what makes this able to be determined by a jury, and that the judges should stay out of it and not come along and say, I am now going to define for everyone what pet is or what this means and tell everyone this is what it means as a matter of law.
See, I take it to run in the opposite direction, which is that we, the courts, do not want your clients and all the other homeowners associations across the state and their members constantly coming to us saying, help us figure out what is a household pet? What is all these other questions about? What is a flag? What is this? What is that? All these restrictions that appear in these restrictive covenants, and that it falls on your client to write terms and define them in such a clear way that there is no ambiguity, and that we could simply ask a jury in a case like this, were they selling the eggs? How many chickens were there? You could instruct the jury to resolve the fact questions and then just examine, based on now we know the facts, as a matter of law, does it meet this legal definition or not? And so it's your client's fault for not writing a clear enough definition, and that means the landowner wins.
Well, I would turn it back on you, Your Honor, and say that you quibbled with the court's definition of pet in Steiner. If my client had defined pet as they did in Steiner, you would stand up here and say, well, it's still ambiguous because I've got my hermit crab. So I think what you're asking is an impossibility that to define all these things. You mentioned the word flag.
I think you misunderstood me, because if you had in this recorded instrument a statement that said a domestic animal is one, or a household pet is a domesticated animal kept for the pleasure of the family or social unit living together in the same dwelling, then I think you would tell the jury, okay, you've got some fact, if there's fact disputes, you got some things to resolve. Is this a domesticated animal? Is it one kept for the pleasure of this family? Is the family all living in one dwelling unit? You answer those fact questions, and once those questions are answered, the judge says, okay, then as a matter of law, it does not fit the definition. And the problem is, we don't have that kind of definition. We have this hopeless ambiguity about what is a household pet? Is a chicken a household pet? What if you have a dozen chickens, 60 chickens? It just seems to be so subjective that we can't reach an answer, except to do what happened here, which is just to tell the jury, well, use your instincts. And that seems to me counter to our law that says if there's questions like that, ambiguous questions, the landowner wins because we construe it in favor of the free use of the property.
If you follow that line of logic, Your Honor, then any animal becomes a pet. Because you have a herd of elephants in your backyard and you say, they're my pets, I love them, I care about them, they're my pets, it's ambiguous, I get to keep the pets. And I understand that's, in essence, what you're saying is then it falls on us as the homeowners to draw it more clearly. I would argue, while I don't advocate that this is the most clear covenant or restriction that's ever been drafted and could have been drafted more artfully and better, what you're asking for is a definition. Well, is it a domesticated animal? Is it this? I think the drafters, the homeowners associations, do believe saying a household pet is a clear enough understanding that a reasonable person could understand what that means, and that it may mean different things in different circumstances, and it needs to be resolved factually by a fact finder, that it is not a question of law because it depends on the type of animal, where the animal lives, how many of them there are, and a host of other, and how the people treat them, host of other factors.
But don't you see the problem with, if what we're saying is this is a recorded instrument, so this has a legal meaning, we just look at the intention of the parties and say every word, just like in a contract, means what the parties intended it to mean. And then we say, but actually what it'll mean is just when you go in front of those 12 people, do you get lucky and you have 12 people that thought it was normal to have 30 cats? And if so, then 30 cats, and another group of people may say, well, at that point you're breeding cats, you're not owning cats, and so those can't be your household pets anymore. And it seems to me we can't just let it be sort of the whims of the understanding of the jury. The point of the jury is if there's a dispute, like for example, did you sell the eggs or did you not sell the eggs? How many chickens were there? Those are fact issues the jury can resolve. But the meaning of a term in an instrument like this just isn't something where we just say, go figure it out, 12 folks, and let us know. That's just not how it works.
I guess I would come back, Your Honor, to my initial point, which is I do not believe household pets is such a ambiguous or foreign concept that a jury of 12 people cannot understand it, any more than they would have trouble understanding the definite, is it a domesticated animal? Well, what does domesticated mean? Do we then have to define the word domesticated within the definition of pets? You can break that down repeatedly and go down that rabbit hole. I think that the drafters were clear enough to say it is understandable to reasonable, ordinary, prudent people to understand what household pets are.
Well, Counselor, I have a follow-up with this because I like to consider myself a reasonable person, but I'm really grappling with the fact that it does say, as defined by the Union County Animal Control Ordinance. Then I flip to the ordinance, and the ordinance says any live vertebrate creature, wild or domestic, other than human beings endowed with the power of voluntary motion. What am I to do with that? How would a jury understand what that means?
Well, that's the leash provision, Your Honor, that is entitled pets, but it talks about the leash provision, and it defines animals for purposes of keeping them on a leash with that ordinance. It doesn't define pets as animals as that ordinance.
But doesn't it follow if you have an animal on a leash, it is very likely a pet or not? Or what would a jury think of that?
I mean, Your Honor, I'm not going to suggest that if you have an animal on a leash, it's not most likely a pet, but it's not. There are circumstances where you could put a leash on some animal that you've caught or trapped or whatever that is not a pet. I mean, it's possible.
But does this not cloud the issue and make it less clear than more clear when you're saying you can leash up these animals based on the Union County Animal Control, whether they're pets or not, but then ask the jury to find what a pet is?
I think, in my view, Your Honor, it's apples and oranges. It's saying that when we're talking about leashes and what animals you have to have on a leash, you have to have all animals on a leash, any vertebrate, that is yours, that's wild, domesticated, et cetera, et cetera. In the livestock provision, which talks about what animals you can have on your property and consider pets, it's a different definition. It is a different view. It is, you can't have, I think the original intention, quite honestly, our position is it says no poultry of any kind. I think it's poorly written because it's got the exception for household pets, but I think the original intention was no chickens, is what they mean by that, no poultry of any kind. I don't think they meant no poultry of any kind except for chickens you love and squeeze and care about.
And this certainly isn't in the record, but I know in most law schools, at least when I was in law school, there's a famous case about what does chicken mean. Is it a frying hen, the plump, or the stewing hen? Well, what does poultry mean? Is that this? I mean, that's the same ambiguity question, and I have the same concerns about property rights, and people need to know what they can and cannot have on their property, and they need to know what they're buying when they purchase, because these are restrictive covenants that run with the land.
Yeah, I think they do have to understand what they're buying. They have to read the covenants, and they have to determine, okay, it says no poultry of any kind except household pets, and they've got to take some leap of faith as to how that's interpreted in that HOA. If it says no flags, to use Justice Dietz's example earlier, what does that mean? If I put a little flag on my antenna of my car, is that considered a flag and I park in my driveway? I mean, you can run into thousands of these, and the most careful drafter in the world can try and define every term, but every definition then uses terms that may need to be further defined, which may use terms that need to be further defined. And you can run this to the ground where you are trying to address so that there is no wiggle room, but at the end of the day, you eventually have to come up with some word that two different people may interpret differently. And there's no escaping that. And I think pets, like the Bryan case, viewed it. The Bryan case basically used a very similar restrictive covenant, and the Court of Appeals, I think appropriately, just said, look, HOA is not entitled to summary judgment. This is a question of fact that a jury needs to decide. And that's how these things should go along, because, as I said before, I don't think pets are such a confusing term that the failure to define them renders the covenant ambiguous or unable to be understood.
But wasn't the questions there, like, did they name them and they let them inside? Like, in other words, there were discrete fact questions that were disputed. And I recognize there could be some here as well. Like, were the eggs from these chickens sold and things like that? And it seems to me that you would certainly need to send those questions to a jury if there was a dispute and the jury needed to decide what the truth was. I'm just struggling with the higher level question of whether we can just sort of say, man, this is a tough issue. what a household pet is, because for every person, it's so subjective. Every person may have a different view. Let's just choose 12 random people and let them decide. That doesn't seem like what we do with a word in a recorded instrument, and that's what I'm struggling with.
I think we do that with words in recorded instruments all the time. You have to determine. It may say, a party. You got to determine which are the parties of the instrument, and it may be clear. It may be obvious to everyone. But at some point, as I keep getting back to, you have a term that everyone just has to say, okay, this is the term, and it may not be defined, but we're going to use our common sense and reasonable interpretation, and that's what we're going to go with.
Wouldn't ordinarily in a case like that, if there's truly an ambiguity where we weren't sure what the intention of the parties was, because that's what governs how we know what the word means, that's where there would be things like parole evidence that would come in to help us understand what the intent was when this was drafted, of what the word would mean. And I guess that's what I'm searching for. In other words, there's ways the law have to structure it to find out and then determine, are there fact questions now that we know the meaning that we need resolved. And here what it seems like has happened is instead we just said, well, this is a very difficult question. Let's let a jury do it instead of the judge. And I don't know if that's what the law requires here.
I think, Your Honor, to step slightly back, the provision says can't be bred, kept, or raised. Those words aren't defined either, but I don't think we're quibbling with those words because we believe we have an understanding of them. We don't define them. And at some point where your argument goes is that the HOA is then responsible for defining raised, bred, kept, lot, dogs, cats, house. I mean, it's defining every term. And as I said, each definition begs another question. I keep coming back to the idea that pets, whether it's interpreted by 12 people of a jury or 7 people on this court or 3 people on the Court of Appeals or a single judge at the trial level, it's someone putting their definition in it. You disagree with the Steiner definition of pet. I'm not sure that there is a universal accepted definition of what pet is, nor do I think the Supreme Court of North Carolina should create one, which is what they would be doing, is creating a definition of pet that apparently, if your position prevails, doesn't include the Steiner definition or the dictionary definition.
Right. Well, that's why what I'm proposing is we will not engage in that practice, and neither will juries. If you didn't make it clear enough, you lose and the homeowner wins. And that the lesson to your client and other homeowners associations is draft very clear, restrictive covenants with intelligible principles that can be applied by anyone to understand this is how I know what kind of animals I'm allowed to have on my property and which I can't.
I understand what you're saying, Your Honor, but I think that's imposing an incredible burden on drafters of documents and covenants that if they define it, as you alluded to earlier, as a domesticated animal, then someone comes along and say, well, we got domesticated. It's pretty ambiguous. Somebody might think domesticated means this, and somebody might think it means that. And I mean, it's just we have no chance of winning because someone creative lawyer could always come along and say, hey, that term right there is ambiguous. Here are 2 possible definitions. Courts do not have consistent definitions of legal terms throughout our history. So
I see your time is short, but I would like to give you the opportunity to help me understand this. I draw your attention back to the provision number 12, pets, and it refers to the Union County Animal Control Ordinance, and then it does say, and shall be leased when off the owner's premises. It doesn't say lease require, it says just pets. And so reading that together, one could very easily conclude that a pet is being defined based on the Union County Animal Control because it says as defined. It doesn't say leashed. It does. The last of it does. So I know your time is short, so can you help me get comfortable with that?
yeah, the provision is titled pets, but it doesn't say pets as defined in that ordinance. It just says animal as defined in that ordinance. And as we pointed out in the briefing, that leads to one of 2 possibilities. Either this provision, livestock provision, then reads, no other animals shall be raised, bred, or kept on any lot except household animals. So no animals except household animals, which has 2 possibilities. It elevates the word household, so then we're elevating the importance of household which these chickens were kept outside, and I would think they would lose, or it makes no sense because it says no animals except animals, which renders it pointless. So that reading would render the livestock provision pointless unless you read it to say this is just talking about what needs to be kept on a leash, and their animals need to be kept on a leash, and the pets is just an identifying. It's not this is a definition of pets, but rather a helpful index for, oh, I want to see while I'm skimming through the covenants, what do I do if I have a pet, and things like that.
But isn't the problem that if we assume that, okay, one example is you often see if it's a pet that you're going to take from your home and take it outside, you often, it's something you have on a leash. But then even just looking at the definition, so it says dogs, cats, other household pets may be kept provided that they, which of course is referring to household pets, provided that the household pets, parentheses including horses. And already I'm lost again because I say, if you ask me what a household pet is, I would never name a horse as one of them because the horse is in the barn. It's not something I'm bringing in as one of my household pets. And you see how it just seems so difficult to have an answer here. And why isn't that on your client to clear it up?
And the only point I make about the horses is it does earlier talk about you can have 3 horses. I don't think that's referring to horses as household pets. That's saying this commercial clause applies to horses as well, which are their own separate thing because you can have a maximum of 3 horses, period. However, no other animals shall be. So it's this separate thing. I wish I could answer your question in a different way than I already have, but I would keep coming back to the idea that I think you're asking an impossible burden on drafters of covenants to define every single term and then define the terms that are used within that definition, which then defines the terms within those definitions, and that pets is a sufficiently understandable term. It is not some esoteric term that no one would understand. It is a sufficiently understood term that a jury can make a determination that they know it when they see it. And that's what happened in this case. And so I would ask that the court reverse the decision of the Court of Appeals and reinstate the decision of the jury. Thank you. I'll reserve the remainder of my time.
Thank you, counsel. We'll hear from the appellee.
May it please the court. I'm John Bloss, along with my co-counsel Margaret Chase, here on behalf of the Schroeders, the appellees. A very basic and very important difference in the parties' positions in this case relates to the role of the jury in interpreting the language of a restrictive covenant. The Court of Appeals described this issue in footnote 2 as a fundamental problem of the lack of an interpretation of the covenants by the trial court before considering whether any issues of fact remain for submission to the jury. This played itself out in several different ways. First, as Justice Dietz pointed out, this court has ruled in the J.T. Hobby case that restrictive covenants are not favored by the law, must be strictly construed. And the court said that this canon of strict construction is based on the public policy that the free and unrestricted use and enjoyment of the land should be encouraged to its fullest extent. In the Steiner case, the Court of Appeals said that restrictive covenants will not be enforced unless they are clear and unambiguous. The jury was not allowed to hear these rules of construction before its deliberations because the trial court refused to instruct on these issues and denied plaintiff's request to read language from the case law, this language from the cases that I referred to. More particularly, the Court of Appeals has interpreted this substantively identical covenant language to hold that the term household pet, if it's not otherwise defined in the covenants, means a domesticated animal kept for the pleasure of or relating to a family or social unit who live together in the same dwelling. Further,
So what do you do about my question of, that's the language. And so we apply the Court of Appeals definition, and suddenly some homeowners association is knocking on its members' doors and saying, we heard your kids have hermit crabs. Remove them. No household pets. Nothing but household pets. And that's not a household pet. I mean, that seems to me, again, to run counter to
I agree with you. I agree with you, Your Honor, that to me also runs counter that a hermit crab should be a pet. I will say that the point I was getting to is that it's well established that interpretation of covenant language is a matter of law for the judge and not the jury. And
So what I understood your friend to say in response to that is, but the meaning of just the words we use in the English language is not something that the judge needs to spell out to a jury one after the other. Certain words just are such a part of our common English usage that you don't need to define them for the jury. And so I gather what your friend is saying essentially is the jury here must have gotten together and said, if you have 60 chickens, nobody has 60 chickens as household pets, so they can't be household pets. And that's the sort of fact question that a jury has to answer. So I guess respond to that. That seems to be the strongest argument your friend made.
so the fact that household pets, I absolutely agree. There are a number, all kinds of things that don't have to be defined. Household pets, as we've seen, different people think of it differently. And the word, and in fact, shortly after our jury verdict, the Court of Appeals issued the Bryan opinion, which said that chickens qualify as household pets. But that hadn't been the case at our trial, and it left open for the HOA to argue chickens could be pets, but they're not household pets. In other words, and as you pointed out, horses are treated in the covenant's language as being household pets. So I think it's an ambiguous term. Court of Appeals says if it's ambiguous, you don't enforce it at all. In the Steiner case, they say that an ambiguous term in a covenant shouldn't be enforced. In any event, the law
Comes from our holding about the interpretive rules of restrictive covenants, right? We just have to.
I think that's
not enforcing it at all would be because not enforcing a restrictive covenant is the interpretation that favors the free use of land.
I think it follows from this court's holding in J.T. Hobby.
How about the term "no poultry of any kind"?
Yes, sir.
How is that ambiguous?
And that was, again, the defendant's primary argument in the trial court was that when it says no poultry of any kind, you stop there. But the language continues. It says, except that household pets can be maintained. So poultry is prohibited, except that household pets can be maintained. And the Court of Appeals ruled that this language means if your chickens are household pets, they're allowed in the face of that covenant. And the defendants concede that point in their brief. Here, the trial court refused to instruct the jury on the Court of Appeals interpretation of substantively identical covenant language and denied the plaintiff's request to read the relevant language from the cases, which left the jury completely in the dark as to the strict construction rule as well as the meaning of household pets as articulated by the Court of Appeals. And the trial court judge at page 3 of the transcript explains that in terms of the instructions to the jury, they'll have to find out in their own minds, based on the evidence, what the ordinary meanings of those words are. Any reference to any legal definitions that would be proper to include for jury instructions would have to be referenced somehow in the covenant or restriction language itself. Again, this runs afoul of the rule that interpretation of a covenant is a matter of law for the judge. And in fact, in the Steiner case, the court couldn't have issued summary judgment as to the goats being household pets because the meaning of household pets would differ from jury to jury. And likewise, in this court's J.T. Hobby opinion, this court couldn't have held as a matter of law that a group home was residential property because if it was up to the jury's common sense on a case-by-case basis, there could be no such ruling as a matter of law on the interpretation of covenant language. In the defendant's view, the meaning of a the appellate court's decisions as to the meaning of covenant language does not control in later cases and should not even be shared with the jury for fear of impacting their application of common sense. If this were the law, there could be no certainty about the meaning of the covenant language, and instead every case would be left up to an individual jury's interpretation of the language, which would result in endless litigation. If this court held very clearly this language means X, that would not, under the defendant's view, be instructed to or even allowed to be shared with the jury, which would be deciding the issue based on its own common sense. In this case, a reasonable, properly instructed jury could only have ruled that the Schroeder's chickens were household pets. All of these chickens had names. They would come when they were called. Mrs. Schroeder spent an hour and a half with them every day. She had a personal relationship with each one of the chickens. She invited them into the house, gave them spa days. We have in the record and shared with the jury photos of this happening, and more importantly, videos where Mrs. Schroeder goes into the barn and the chickens are crowding around her, wanting to be picked up and scratched.
What if there had been 300 chickens?
If there were 300 chickens, I think you would get to a point where she doesn't have a personal relationship with each chicken.
But suppose she says, oh yes, I know all their names and I do all the things that you just said.
I think if she said, I knew all their names and all this, and it was just her saying it, you could run into the problem of it being a jury issue, as it was in the Bryan case. In the Bryan case, the plaintiffs testified that these are our pets, but they also testified the only time they went out there to visit the chickens was when they fed them.
No, I'm saying suppose she says all the same things
Yes,
that she said here,
Yes, sir.
but it's 300 chickens. You don't think a jury might say no?
I think what we have in this case is not just Mrs. Schroeder saying it. Every witness said that these were her pets. She had the same relationship with these chickens as she had, other people have with
Well,
more
those
traditional
witnesses, and correct me if I'm wrong, but they didn't say, well, I've seen her interact with each one of them. They just said, I've seen her interact with the chickens, with some of them, and she acts like someone who she treats them like someone would who regards them as pets.
They testified she had a personal relationship with these pets, and each one knew their name and would come when called. And in fact, the HOA's representative admitted that he had no evidence that these were not her pets.
What if there were 500 chickens?
I think there gets to a point where everyone, all of these independent witnesses are not going to agree that she has a personal relationship with the pets.
Well, they might say, anytime I'm around her, I say, well, what's that chicken's name? And she can, give me a name, and
Yes,
she
sir.
can call it, and it comes to her, and all that.
Aren't you conceding too much? Because isn't the point that if you're some kind of savant and you own 1,000 chickens and you know every single chicken's name and you devote your entire life to bringing them in one by one and taking care of them, that under this restrictive covenant, those 1,000 chickens are household pets. So, and if the homeowners association doesn't like that idea, they should define it in the restrictive covenant and say, except for household pets, but you may have no more than 10 household pets or whatever they think the limit should be. And there just aren't any limits or any definitions or anything else in the statute that allows to resolve those questions.
Covenant does not have any maximum number, and I'm not, and in fact, it does have a maximum number of horses. You can only have 3 horses, which shows that they know how to limit the number. I'm not conceding that 500 chickens couldn't be pets. I'm just saying you're going to get to a point where there's so many animals that all the witnesses are not going to concur that these are your pets, in my mind.
What if it's 10,000 chickens?
If it's 10,000 chickens, again, if the evidence is undisputed and even the defendant admits that they're your pets, then there's no triable issue as to whether they're your pet.
What I'm struggling with is, isn't there some point at which it really does become a jury question?
I think,
I can keep the numbers going up.
yes,
I
sir.
can go
And I understand
100,000.
that.
I can go even higher.
And my point is, when everybody, including defendants, admit that these are your pets, then I think there's not a jury question. And there are certainly ways to restrict numbers of chickens in covenants or by ordinance. And in fact, this covenant has a provision relating to nuisance, which was not invoked because the neighbors couldn't even see these chickens, smell them or anything from around their property. So
I guess what I'm trying to get at is, don't you get to a point where it really is a credibility issue and therefore an issue for a jury?
I think that if defendants admit they're your pets, then it is not a jury issue, Your Honor. That's what I believe, and I think that's how the Court of Appeals came down on this, is there's no restriction on numbers in the covenants. And if you have 10,000, somehow somebody has 10,000 chickens and they have a personal relationship with each one and the defendants acknowledge that, then there's no jury issue as to whether they're pets.
I have a slightly different
Yes.
A slightly different question, which I realize the jury didn't reach, but there's the second issue of whether they're being kept for a commercial purpose.
Yes, sure.
And it seems to me that to some degree the facts have been blurred. Some of the facts that might suggest commercial purpose are being considered into whether or not they are pets. But in this case, were there disputed issues of fact about whether or not there was a commercial purpose?
There was the only evidence relating to the whether there was a commercial purpose was a Facebook post from a couple of years before where she had said, "I sell farm fresh eggs," and she and that I want to give these away to a food bank, these extra eggs. There was no evidence. The neighbors said they never saw any evidence of commercial activity. The Schroeders said they never sold eggs. And in fact, under the Court of Appeals jurisprudence, the commercial purpose has to be the primary purpose for it to be considered a commercial purpose. In other words, there could be a commercial purpose for these chickens only if the primary purpose for raising the chickens was to make money. And in this case, the idea that they're in it to make money is absurd. I mean, they spent thousands and thousands of dollars on these chickens, and they kept them on the premises while $100 a day fines were accruing for almost a year. When they couldn't justify that anymore, they relocated them to a friend's house an hour and 20 minutes away, and Mrs. Schroeder traveled an hour and 20 minutes each way to visit them. So there is no, I would submit, there is no jury question here about a commercial purpose.
And Counselor, I would like to give you the opportunity to address my concerns about Section 12 pets that talks about any person or whatever shall keep said animals, but said animals as defined by Union County Animal Control. And then it says, and shall be kept leashed when off the premises. That to me is an ambiguous type statement because it's entitled pets, and one would expect that that would be somewhat definitional. What is your position there?
I can tell you my position in the trial court was that refers to the broad definition of animals in the Union County Ordinance, which is any vertebrate self-locomoting species. And I thought that was important because of the defendant's position that chickens could not qualify as pets. That since the Bryan Court has ruled specifically that chickens can qualify as household pets, I think it's definitely, what you're pointing out is definitely consistent with the Bryan Court's ruling. That any kind of vertebrate animal under the Union County ordinances has the potential to be considered a household pet.
Well, and I think he would agree with you that it has the potential, but with respect to this particular provision, if I understand his argument correctly, is that it's really about what needs to be leashed and penned in as opposed to defining what a pet is. So how do you answer that?
I think that, at least I'll tell you what the Court of Appeals ruled on this, which is that it referred to Section 30 of the covenants, which says the titles of the provisions do not control. And the Court of Appeals said that provision does not define pets. It does not define pets. However,
do you agree with that interpretation, sir?
I don't think that just because it's an animal under the Union County ordinance that it's automatically a pet. I think there has to be a relationship of love and affection with the animal before it becomes a pet.
Also, and I keep coming back to this, but I believe hermit crabs are invertebrates.
Yes.
And so
there would be an argument under these covenants that because of the reference to the Union County ordinance, the hermit crabs aren't pets, and there would certainly be an argument that they're not domesticated and aren't pets. And nevertheless, I agree with you, they should be considered pets, but that's not my argument today, luckily. So again, this court has ruled in the Burnett versus Bank case that it's appropriate for the trial court to grant a JNOV for the party with a burden of proof where the non-movement establishes the proponent's case by admitting the truth of the basic facts upon which the claim of the proponent rests, which is exactly what happened here. The defendant admitted the truth of the fact that these are the plaintiff's pets, and so JNOV should have been granted. And
what is now this may not be fair to ask you, it's
yes, sir.
probably better directed to the other side, but what is the evidence that these chickens were kept for utility than for pleasure?
I think the defendants have pointed out to the eggs, the fact that there were a lot of eggs on the counter at one time, and the fact that Mrs. Schroeder had posted on that Facebook post that she sells farm fresh eggs. I think that is their evidence of utility. And our point, our response to that is chickens lay eggs. There's going to be, if you have a lot of chickens, there's going to be a lot of eggs if you have a small family that the Schroeders had, and they would give away when they built up a sufficient number of them. And again, the undisputed evidence from the Schroeders is that they were not selling the eggs, and certainly no one would argue, I think, that that was their primary purpose in having the chickens, was to sell the eggs, which is what would be required for a holding that these chickens were kept for utility as opposed to pleasure.
So really, in your view, they're relying on the number of chickens. And
that seems to be their main point, Your Honor.
Well, except I guess then that raises the question about another ambiguity in the restrictive covenant, which is what if Mrs. Schroeder has a different view of the chickens than Mr. Schroeder? I can tell you my husband has a different opinion about our dog than I do.
Right, and I think that was one of the defendant's points, was that Mr. Schroeder, who travels all the time and doesn't spend an hour and a half with the chickens every day, didn't know all the chickens' names when they had...
But so the covenant says person in section 2, which is singular, but then without giving the jury any instruction, you have evidence that seems to suggest it's somehow legally relevant what Mr. Schroeder versus Mrs. Schroeder thinks. So I think, does that ambiguity also go to whether or not we should enforce the term or consider the free use of land in this?
My son grew up, had a snake that my wife would have nothing to do with, yet it was still a household pet. I think if a member of the household has a relationship of love and affection with it, it's a household pet. But to the extent that it leaves open an argument that every member of the house has to love and have affection for that animal, it does become ambiguous. And so I would like to say that the jury here was prevented from receiving the court's, this court's and the Court of Appeals guidance on the issues before it, and that no properly instructed, reasonable jury could have ruled against the jury on the two jury issues, and the Court of Appeals ruling should be affirmed in all respects. In the alternative, if this court does believe there is a scintilla of evidence on either one of the jury questions, a new trial should be ordered. Thank you, Your Honors.
Thank you. Rebuttal.
I'm going to do my best to get to everything in 3 minutes. Chief Justice Newby, you asked about poultry of any kind and then the household pets. That is where I would say that we have conceded that because there was an ambiguity in how that phrased, and it was interpreted in favor of the free use of land, even though I think the intent was no chickens, no poultry of any kind, but there is this except. I don't think the except was meant for the no poultry of any kind, but it was, but we have allowed that interpretation because of North Carolina cases. As far as the personal relationship and the utility question that Justice Allen asked about, the utility, I think the reason the Steiner court made such a big deal out of the Nigerian dwarf goats not being able to produce milk is that because when you produce milk or eggs, you have demonstrable utility. In the record, they ate the eggs, they gave the eggs away, they used the eggs. The chickens had some measure of utility. I'm not disputing that plaintiffs, particularly Mrs. Schroeder, cared about these chickens. That is the essence of a factual dispute, is that they have evidence on one side, we have evidence on the other side, that, whether they should be considered pets. This is where, your hermit crab, 4 hens in Bryant, or 60 chickens, that is the essence of why we have a jury system, is to allow the jury to take in all this evidence and decide. What is lost, I think, in the ambiguity discussion is it keeps striking me that, by ambiguous, what you really mean is a question of fact. Are these pets? I understand, Justice Deitch, you're troubled that pets is an ambiguous term. However, I think it is an understandable term that a jury can evaluate all the evidence they're presented with on both sides and can come to a conclusion. As far as the argument that we admitted they were pets, I respectfully disagree. The testimony from Mr. Fry was, do we have any indication that Mary, Mrs. Schroeder, lacks a relationship with the chickens that other people have with more traditional pets? He didn't say, I agree they're pets. He said, I understand they have a relationship with them. She cares about them, but there's this other evidence. You're using the eggs. You have 60 chickens at one time. Mr. Schroeder doesn't know the names. In fact, you don't know the names of one of your roosters, Elvis, things of that nature. So there was this scintilla of evidence that precluded the Court of Appeals in this court from overturning the decision of the jury. And so we would respectfully ask that that decision be reinstated and that no additional trial be ordered and this matter be concluded. Thank you, Your Honors.
Counsel, Ms. Clark.
All rise.